Hello, good afternoon, and welcome to The Law. This is your health law, and it is your legal light. I'm Samson Ladi Anyenini. This afternoon, we come your way by popular request to bring you part 2 of what we did last week. Of course, at this point, you know the very basic things that must go into what will constitute a valid will, the importance of a will. And of course, we need to know if you did not make a will, what happens behind you after you are dead. We'll be right back.
Then the first point about a will, a lot of people think that there is a bullet in a will. In other words, once you're making a will, you're pointing a gun, or the will points a gun at you and shoots you after you've made a will. That's a misperception. Also, people think that wills are for people who have reached a certain age.
Yes, that's what the third person said.
People also think that a will has to be made by people who have acquired wealth up to a certain stage. It's a misperception. I think the whole of this is about what you said at first. Appointed unto man wants to die. Nobody knows when he's got an appointment with God. And what it means is that before that day that you and I do not know, I mean, a will makes it possible for you to distribute your estate in a manner that you want it to be, and to whom and who must get what. And then there could be no better way of living this world. We've got a law in this country which does not recognize religion when it comes to making a will. You can either live this world in one of two ways according to our laws. Either you live the world with a will, in which case you got what we call a tested estate. Or when you die without a will, we call it interstate estate. And both are regulated by law. Essentially, when we talk of estate, we're talking about your lawfully acquired properties, everything that you acquired during your lifetime, everything that you've got an interest in, even if you've got reasonable expectation to know or to believe that there are properties that may be yours even after your death, or even if at the time of making the will it is not yours, but then you have reasonable expectation of acquiring them, it becomes part of what we call your estate. Essentially, everything that you lawfully are entitled to, however you acquired it, as long as you've got an interest. There are things that you may even be, you may own it together with others.
Okay.
Your portion of what you own is what becomes part of your estate. The impression is being created that a will must necessarily be made by a lawyer. A lawyer is not mentioned in the Wills Act at all. Anybody who can follow what I've told you can make his will. Right. I've had a few cases where people have made their own wills, they got their witnesses, got executors, everything right, and the law will recognize it.
All right. Welcome back. And once again, we are privileged and indebted to Kweku Pencil, head of Pencil and Co. We're dealing with interstate succession law, the PNDCL law 111. Senior, thank you so very much once again for coming.
Thank you very much.
And the last discussion generated such interest even among lawyers. For the better part of the week, when I went to court, I had one lawyer or the other asking me that we needed a part 2, and that there had been some enlightenment even to lawyers. So I will say, on behalf of all of my friends and our viewers, that we are indebted to you. Thank you very much.
We're grateful to God.
Right. So we have just done a bit of a recap to bring you up to speed where we left off last week. Today, we are proceeding to go into, if you don't make a will, what happens? The best thing, as has been explained, is that you make a will. Once you make a will, you have determined how your property which he calls the estate, should be distributed in your absence. If you don't make a will, what should happen? So, we may start from the point where you sought to explain to us that there are people that may not be mentioned in a will but will be entitled. I want us to move from there and then dovetail it into interstate succession. Once again, who are this category of people? Because I find that we had a lot of questions that we couldn't answer, and some of them revolved around this.
Yes, what happens is a man may make a will, but whatever happens, even with regard to will, there's a possibility that some properties that the testator had for some reason or the other could not be captured by the will. Because people acquire properties even after they've made a will. There is generally what we call a residual clause that we will normally put in a will, and that clause will normally try to capture properties that you will not have acquired at the time, but which possibly may come your way, and then you would expressly provide that those properties may go to specific people. But because wills are made by human beings like you and I, sometimes people skip it. Whichever way, almost always, properties fall to be distributed which are not captured by a will. That's just one side of it. So in respect even of people who have made wills, there is a possibility that they will have properties which would have to be governed by intestacy. So that's one portion of it. The other portion, obviously, is for people, and they are the majority. In Ghana, I believe out of every 10 people, about 8, possibly 8, will die without a will, because we don't have a culture of making wills. From my own experience, no one woman ever walked to me to make a will. I don't know why it happens so. It's almost the men who make wills. But like I said, from my own experience, out of every 10 people, I believe about 8 would not make wills. They would die. And when they die and they have properties, issues arise. Then we have a law called the PNDCL Law 111. It's a 1985 law that was passed to regulate the estate of all people who die without a will, but who leave properties behind that ought to be administered.
Right. Before that, the focus of the question was also about persons who may be entitled to the estate of the testator. Remember, we explained that the testator is simply you, the one who has made the will.
Yes.
Who may be entitled, but the will has not provided for them.
Whoa, that is about, like I said, a reasonable provision. You have the law, that's the law of wills, provides for a situation where a spouse, a parent, or a child under 18 years may go to court and make an application for what we call reasonable provision to be made out of the estate of the testator. And subject to the peculiar circumstances. The peculiarity of the circumstances means, for instance, that wills are treated as sacred documents. People may have good reason why they want to disinherit some people. And indeed, for some of them, they would expressly, specifically state reasons why they want to disinherit some people in the will. And some of them, of course, will go about lamenting about what the particular person did and so forth. Some of them, in order to express their intention of deliberately disinheriting others, they would then make provisions. I mean, very peppercorn. I mean, some scanty, with due respect, maybe very insulting provisions that would show that they have not forgotten you. And like the example that I gave, I've got a few wills in which the person has stated that they should buy his executors must buy a King James version of the Bible for their son or whoever it is who have been mentioned by name. Some will say it in respect of their wives, and so forth and so on. So when those things have happened, and the victims of these provisions, I mean, they feel cheated or for any reason can demonstrate a court of law that the kind of provisions that were made in the will or non-provisions that were in the will are such as to affect them in some particular way, the rule or the law permits you to come to court. But when you come to court, you've got a long road. I mean, you've got a hill to climb. So that is about it. That's about it. The courts will rarely interfere with a person's will. And therefore, you must demonstrate, because sometimes provisions also are made. I've just said these other things, but sometimes the testator has actually made provisions. In your lifetime, he's bought a house for you. And therefore, whatever remains of his estate, he believes he's entitled to distribute it in some way. And it will appear as if you have been disinherited, when indeed and in fact, in your lifetime, he has already settled you.
Okay. So last week you explained that to make a will means that you want to die testate. So now you are talking about interstate succession law. What does it mean to die intestate?
Simply that at the time of your death, you had not made a will. You have not made a testamentary disposition that shows who must get what of your estate. And that is it. That's why the law was made, to intervene. And the law was made against a background of a history of succession laws in this country that, if I may put it, I'll put it very bluntly, were quite wicked. I mean, under customary law, cut across the whole of the country, for instance, a woman was, for instance, was more or less held as a property of the man, and when the man has died, she was not entitled to any portion of his estate. Children, for instance, were held as not entitled to any of their father's estate, and even after their father's death, they could only stay in their father's house subject to good behavior, and such obnoxious practices. I mean, a very long history, but the long and short is, in 1985, this law came in to cut across or divide from whatever portion of this country, whatever religion, whatever tribe, whatever portion. So the Interstate Succession Law came to provide a blanket law that seeks to regulate anybody who dies in Ghana and you are Ghanaian, even a foreigner. If you died in Ghana and we didn't leave a will, then the Interstate Succession Law will come in to apply to your estate.
So if a person died without making a will, still people or family members are not at liberty to deal with the person's estate or properties the way they want.
No, we don't have a right. The law does not permit anybody. In fact, we call it intermeddling. And anyone who does that is called an executor de zone tort. Executor de zone tort. And that is to say a false executor. If somebody dies, you haven't got letters of administration. Well, as you said, intestacy goes with what we call letters of administration. That's also governed by a separate law. But the interstate succession law is what provides for how the estate should be distributed. There is a rule of procedure as well as a substantive law that also governs how people who want to administer estate must go to court and apply for what we call letters of administration. If you have not done that, and then you somehow take over the estate and begins to do one thing or the other, we say your conduct amounts to intermeddling. And when you are sued, you are called executor de zone tort. That is to say...
Does this apply to everybody? Because in our traditional and customary settings, we know that when somebody is not there, this is the next person in charge. And so they take over. And sometimes, mostly, men take over and begin to dictate to, if it is a man who is dead, they take over and begin to dictate to the woman and the children how things have to be done.
That was always the case until the law came in. Once the law has come in, the law now takes the place. And what it means is that for anybody who does that, and in fact, there's a lot of things that people do beyond and even beside what you're saying. So indeed, I need to put it very bluntly that under the PNDCL Law 111, Section 16 of that law criminalizes any conduct that seeks to prevent a spouse, because typically spouses are thrown out. Even though the word spouse is used in as a neutral gender to refer to either man or woman, more often than not, we are talking about women being at the brunt of these customary practices. So when a man has died, people then go to move the woman and the children out of the house and so forth and so on. This time, Section 16 of the PNDCL law criminalizes such conduct, and it prohibits anybody from seeking to throw out a surviving spouse and children from the matrimonial home where the man and the wife and the children were living and subject to specific provisions in the law. No one can do it.
So first, you are saying if someone dies and then some people within the family or from wherever believe that they have the right or they will inherit that person, begin to take control of the person's property, they are committing the offense you call intermeddling.
That is
they are not allowed to do so.
That's a tortious liability. Yes.
Great.
Yes.
And then secondly, that if they take over and try to remove or maltreat the spouse and the children, it's clearly prohibited and it's actually criminal.
It's criminal. I can go to prison if I'm convicted.
Okay.
You could be fined or imprisoned or both. The imprisonment is up to 1 year. The fine is 250 units, which today translates to
3,000.
About 3,000 Ghana cedis. It may look very small, but it shows the intent of the law.
Okay.
And an attempt to ensure that nobody takes the law into his own hands.
Right. So you are referring to
Section 16 of PNDCL 111.
Right. And Section 16.
16A.
Right. 16A says prohibition of ejection of spouses. This thing happens a lot around town. People don't pay attention. Please now listen to what Kuku Pencil is talking about. The law says, a person shall not, before the distribution of the estate of a deceased person, whether testate or intestate, eject a surviving spouse or child from the matrimonial home. So testate or intestate.
That is so.
Whether they have made a will or they haven't made a will.
That is so.
You can't come there and say, get out. This is my brother's house.
You can't do it.
Okay.
I know people do it often, but it's criminal. They don't know.
Okay. You can eject a surviving spouse or child from the matrimonial home, where the matrimonial home is the self-acquired property of the deceased, where the matrimonial home is rented property, unless the ejection is pursuant to a court order, where the matrimonial home is the family house of the deceased, unless a period of 6 months has expired from the date of the death of the deceased, where the matrimonial home is public property, unless a period of 3 months has expired from the date of the death of the deceased.
Yeah, I just needed to add something to this
Many
one. Because,
permutations.
Yeah, because it's very rampant. And a lot of times when these matters come to lawyers, you ask the client to go to the police. The police themselves, they are completely lost as exactly what to do because they see it as a family issue. So what I do without fail is that I would always write to the police and quote the law, because the police need to be, with due respect, educated as to the source of the law.
All right.
And it's that law that criminalizes the conduct. So every time that I have done that, the police know how to stand up and they know what to do exactly in the circumstances. So this is for lawyers, that every time that you are faced with that kind of situation, what you do, make a letter for your client to take to the police and quote Section 16A of PNDCL 111 and give them the facts of the case that makes that conduct fit into that section of the law for the police to act appropriately. Because
it could get to a police officer who is clueless about what this is.
They don't know what this is about.
And there are 4 various categories. Yes. It says, first of all, if the home is the self-acquired property of the person who is dead. 2, it says where the home is a rented property, then the person can only be moved by
a court order.
Yes. And then C, if it's a family house, even a family house, you can't throw the person away.
You can't do that.
Okay. It says unless a period of 6 months has expired from the date of the death of the deceased.
Sure.
Okay. So the only briefing space, grace period, is 6 months if you don't want the person to continue to live in the family house.
So. It means that the person should have been given notice and stuff like that. You know, this is essentially a court trial because, see, notwithstanding the law, there are still people who believe that upon the death of a person, forget about wills and not wills, they still see the deceased as part of a family. And now you must understand that under customary law, virtually both matrilineal and patrilineal, it's families that own properties, not individuals.
That's right.
And when family or members of the family dies, then immediately their properties devolve onto their families.
Right.
And therefore, that has been the customary law, the customary practice, the perception, and it persists up to date. When people have died, then the family members just move in and they believe that the same custom begins to apply.
Right. Why do you think there's a provision for a public property if the spouse, surviving spouse and the children are living in a public property? That one too has been catered for, and it says unless a period of 3 months has expired.
Yeah, a public property essentially means that it will be required possibly for government purposes, to be required for some other purposes.
The person is a public servant.
Naturally.
A duty post.
You're very right. You allow 3 months at least to pass.
Okay.
But the truth about the law is not necessary because of public property, but the entitlement mentality of the family who believes that they can move in anywhere and trace whatever property that their deceased has left behind and go and take hold. Indeed, and in fact, I know for a fact, for instance, that the starting point is they come and lock up the deceased bedroom and stuff like that, and they will take the keys away. But because there may be legitimate reasons for ejecting spouses, the law has allowed these briefing spaces in respect of the peculiar circumstances so that they will still be protected.
Right.
That's the whole idea.
So it's also not just about ejection, but it continues in section 17 to talk about unlawfully depriving the entitled person of the use of part of the property that the person is entitled, a property shared by the entitled person with the deceased, and then if you remove, destroy, or otherwise unlawfully interferes with the property of the deceased person.
Sure. You know, what really happens, like I said, anytime somebody has died, you get the family people who come in. There are all kinds of views that
maybe there are cars parked somewhere, they start moving them away.
They come and move them away. They remove documents. They take briefcases. They take suitcases believed to be containing documents. And some of them, you will never see them again. The whole idea is to ensure that kind of wipe out whatever evidence that will show that the deceased owns these things or these properties. And please, this thing must be set in a very cultural setting. Because, see, I keep making the point that the relationship of husband and wives in Ghana is still cast within a certain cultural background where a man possibly does a lot of things and the wife has no clue whatsoever. This may exist in documents and records that may be even in the same room. I mean, if the woman, for instance, is illiterate, she cannot even read. But if she has access to these documents and she can make it available to some lawyer and whatever, then the lawyer may educate her as to what rights she has in relation to whatever the husband left behind.
Right.
The whole idea of the family moving in to take possession of these things is to deprive the surviving spouse. I'm using woman because, like I said, the woman who almost always bear the brunt of these cultural practices. It is very funny, very interesting how these things never happen to men, because obviously, you never go to a man's house and say, coming to lock up the place because his wife is dead. He'll beat you up.
Yeah.
But it happens to women all the time. So like I'm saying, we're talking about motives. We're talking about what drives people to do this, quite apart from the mentality that we've talked about. The other idea, like I said, is to deprive them of material that they can subsequently rely upon.
Right.
Last year, remember someone was talking about a will that was hidden for how many years? Yeah, the whole idea is to ensure that you don't have access to, if there's a provision, for instance, in the will for you, and as long as the will is not available for people to know, then you don't know what you're entitled to.
Right.
So these are some of the motives
and that leads us to stress the point you made at the beginning again. Once a person is dead, irrespective of your relationship with that person, you are not entitled to try to deal with that person's property unless, if there is a will, it has gone through probate. You have gone to court and have been empowered to come and deal with the property. If the person didn't make a will, unless you have gone to the court and gotten what is known as the LA, Letters of Administration. He just explained, if you don't do that, you are engaged in intermeddling, which is punishable by our law. And again, you will if you did things that deprive the family, particularly the spouse and children, of some of the property, or you eject them, you could go to jail for a year or be made to pay 3,000 Ghana cedis as the maximum fine here. But the law doesn't end there. It says that after you have been punished for doing the wrong thing, the court should do something to the person you have ejected or deprived of the property.
Yeah, essentially, the court has got power. You know, there is something we call mandatory injunction. A mandatory injunction is essentially an order of court that compels somebody to restore, to put back what he has prevented somebody from doing, and so forth. I mean, that's just one of the several tools available to a court of law. So, for instance, in the case that we're talking about, if you threw the woman and her children out of it, the court will make an order for you to put them back.
Okay.
If you remove
that reinstatement.
That is so.
Or reimbursement.
That is so. That's if you cost her, if what you did cost her some money. In other words, you know what people, they remove windows, they remove doors, they remove roofing sheets.
You've taken something and sold it.
That is so. So the court will compel you to restore those things to the position what we call status quo ante. To do it the way that it would have been, but for your wrongful conduct. The court has got that power.
Right.
So those people who are running around and doing all of these things, that's the law that they're looking at, and somebody needs to look them in the eye and tell them.
Right.
Yes.
So it's dangerous. Don't get into it. So if a person died without a will, how does this law, that is the state, go about distributing their estate or property to the surviving children, spouse, children, parents, customary successors?
Well, I'll put it this way. First and foremost, we mentioned anytime somebody dies interstate, some people must come together and apply for letter administration.
Right.
Letter administration typically are applied for by a surviving spouse, by possibly a child representative, and almost always the customary successor of the deceased. And typically, the head of family of the deceased will contribute an affidavit to the application in which he will indicate that the people who have been mentioned in the application are proper persons to whom letters of administration ought to be given to. Then when the letters of administration have been given to, the letter of administration is essentially to administer the estate in accordance with law. By law, we talk about PNDCL Law 111. The PNDCL Law 111 has indicated how the estate of a deceased person ought to be distributed.
Right.
First and foremost, the law deals with a situation where the one who died left behind one house. If the person left behind one house, the law is that the surviving spouse and child are entitled to that house as tenants in common. I repeat myself. Surviving spouse could end up with spouses. Surviving child could be children. So therefore, that's just a term for, because this is Ghana. I mean, a man could have 3 wives, 4 wives, 5 wives, but a woman can never have 2 husbands in Ghana. So the surviving spouse means that if the man died and had more than 1 wife, then all the wives, together with all the children, are entitled to that one house equally. That's what we mean by tenants in common.
So if it is one house that the person who died left behind,
The interstate.
Yes, the surviving spouse and children will not share it with anybody.
No. They're entitled to equally. So
your opinion cannot
no, nobody.
It's a house with so many rooms, so I'm entitled to.
Nobody has got a share in there. The family hasn't got a share. Nobody has got a share. It's only the surviving spouse or spouses as appropriate, and child or children as appropriate, who are entitled, and they hold it equally. So if at the end of the day, the surviving spouse and children, they add up to 10, then the law is that everybody has 1/10 of it. So nobody has got an interest which is bigger than that. That's the first point. The second point is if the one who died left more than one house, then the law is that the surviving spouse and child or children as appropriate are entitled to choose one of the houses.
Right.
And it is interesting that the law goes ahead to say that if for any reason they are unable to agree to choose one out of 2 or several houses, then upon application being made to the court will decide which house they must choose. So that is the second point. There is something the law called household charters. The household charters, in a nutshell, includes everything that is used together with the house. Just everything, call it everything, except commercial vehicle. Except a commercial vehicle.
Okay.
So if the man had private cars, whatever. I'm sorry I'm saying man. I'm talking about the deceased.
So man is also used to represent woman.
That is so. If all the household charters go together with any one of those houses that they will choose.
The law says the household chattel include jewelry, clothes, furniture, furnishings, refrigerator, television, radiogram, other electrical and electronic appliances, kitchen and laundry equipment, simple agricultural equipment, hunting equipment, books, motor vehicles, other than vehicles used wholly for commercial purposes, and household livestock.
You're right. So that's about it. That's why I took out commercial vehicles. Anything other than a commercial vehicle is described by the law as household charters.
All right.
The household charters are also for the surviving spouse and children equally. They take it together with the house.
So from where I come from, if it's my brother something who is dead, I am supposed to inherit the person. I can't go and say, okay, I've seen some cars here, I pick the one I like. I can't say, I know he has 2, 3 houses. I decide which one I like because by custom I am entitled. I can't do that.
Now, when you do that, look at section 16A, look into the face of the prison.
Okay.
Because that's what essentially you're looking at.
All right.
You know, I keep on telling people that what the law does is not to stop people from doing what they want to do, but it shows them the consequences of their conduct or their action. Because the law is that a man expects the reasonable consequences of his conduct. Okay. You must expect everything that you do. That's why we say even your freedom ends where someone's nose begins. Right. So for those who will not listen, for those who believe that they've got a right to do what they want to do, what they need to be told is that they have section 16A of PNDCL 111 that criminalizes that intent that they have. And if it manifests, the chances are that they will see a judge who will show them where, as we say in Ghana, power lies.
Right.
So that's the way it goes.
You're still here on the law. This is your legal light. It is your health law. And on this show, as always, what we do is to bring knowledgeable, experienced lawyers to help you understand the law and empower you. The things that you will ordinarily walk into a law firm and pay money before you get them free here on this show, including today. And like last week, you learned certain things that you don't have to do with a will if you found it, else you go to jail for 10 years. And today, you're also learning free that if you're not careful, you go to jail for 1 year for trying to intermeddle or, as it were, eject and deprive surviving spouse and children of what they are duly entitled. So they are entitled to a house and the household chattel. And the household chattel include motor vehicles other than those used wholly for commercial activity.
That is so.
What else are they entitled? And you said it could be the surviving spouse, surviving child or children, surviving parent, and surviving customary successor. That's a priority according to the law. So why is it only the children and the wife who are getting, or the surviving spouse who are getting everything?
No, that's not about it. I mean, that is to say, after that, that is to say, after the one house and the charters, everything else that the deceased owned, we call it the residue of the estate. The residue of an estate is everything that the deceased acquired in his lifetime besides the one house and the household charters. The law has provided a formula for the distribution of the residue of the estate. And when the law was made, well, the situation was too bad, but somebody had to create a formula The formula is not perfect by way of experience, but I will just tell you what the law says. Of the entire estate, that is to say the residue of the estate, the law says that the surviving spouse is entitled to 3/16. In other words, the law provides a formula as if maybe it is easier for us to quantify it in money terms.
Right.
Because when we talk about residues, it could be all kinds of things. But for the purposes of the discussion that we're having, let's say we've given a value to the totality of everything that we call the residue. And the value of it is, let's say, 1,600 cedis.
Okay.
The law says that of that value, the surviving spouse is entitled to 3/16. In other words, if it's 1,600, then the surviving spouse is entitled to 300 cedis. Then the surviving children or the surviving child is also entitled to 9/16. That is 900 cedis. Of the remaining 400 cedis, the law says that if the deceased left behind surviving parents, then they are entitled to 2/16. That's 1/8 of the residue of the estate. Then the other 1/8, listen carefully, the law says it must be distributed in accordance with custom. A lot of people end up saying that it belongs to the family. The law does not mention family. The law says that it ought to be distributed in accordance with custom.
That means the surviving spouse and children could still benefit?
Naturally. Because the custom depends on whether it's patrilineal or matrilineal.
Okay.
The surviving spouse could go in under the children. Because, for instance, among Gans, I know for a fact that they inherit patrilineally. And according to the Gans system of inheritance, the children own their father's estate. And therefore, if you die, let's say the deceased is a Gan, then that 2/16, that's the 1/8 of his estate, the children could go in there and slug it out with the family. So it is not for the family, as we keep on saying. But if he did not have surviving parents, then the whole of the 4/16, that is to say 1/4 of the estate, then ought to be distributed in accordance with custom. So if, for instance, the person died from a matrimonial system of inheritance, naturally, the man's children are not part of his family. So as I sit here, my children are not part of my family. What it means is that then the whole of that portion will go and be distributed in accordance with customary law, I mean the system of inheritance. So that is how, in the first instance, any residue that was left behind by the deceased ought to be distributed. That is it. That's the formula.
All right. So if the deceased person is survived by a spouse only, so they were childless, or the deceased person is survived by a child only, or children only, or survived by only the parents, or there's really no one to inherit that person, what happens?
There are provisions for all of that. Number one, where the deceased is survived by a wife only, but no child.
Okay.
The law says that the wife is entitled to a half of the residue of the estate.
Okay.
Of the remaining half, 1/4 goes to the surviving parents, and 1/4 falls to be distributed in accordance with custom. That's the way it goes.
All right.
If the man died without a wife and he left a child or children behind, the law says that the child is entitled to 3/4 of the estate. And the remaining 1/4, if he left behind parents, then they ought to take half of the remaining 1/4, and the other 1/4 will be distributed in accordance with custom.
All right.
But if he did not leave behind surviving parents, then the whole of that 1/4 goes to be distributed in accordance with custom. Then we are talking about a third scenario where if he left a surviving parent but without child and without a wife, the law says that 3/4 of the estate ought to go to a surviving parent.
Interesting.
And
Interesting. You're still here on the law. This is your legal light. It is your health law. And I am here in the studio with Kweku Pencil, head of Pencil and Co. Continuing from last week when we spoke about the importance of a will, the essentials, and what you need to avoid. And today we're continuing in the circumstance where people die without making a will, it means they have not determined how their property should be distributed, that is their estate, and the state has now intervened through a law called the Interstate Succession Law. The state will distribute it for you the way the law has provided for. In the circumstances we speak about, who is a child?
The child. A child is any natural born, anybody born naturally.
I'm asking because in Ghana we talk about illegitimate child. This guy, you know, was born out of wedlock. He doesn't belong to here, and so on.
Talk about funeral children. I think
funeral children.
That's about a child has been defined by the law to be anybody that the deceased. First is anybody born naturally to the deceased,
right,
or have been adopted by the deceased in accordance with custom, or anybody that the deceased recognized as his child. And that is it. If the deceased recognizes someone as a child, recognition in law means a lot of things. Possibly has given him his name, so many other things. We can't go into the specific details, but there's always a way by which a deceased person or somebody before he does recognize somebody as his child.
How about the spouse? If it's a wife, who will be the wife?
The wife, very interesting. By law, you know, around the same time that this law was passed, there was also a law that provides for registration of customary marriages and so forth. That law, indeed and in fact, if it has been complied with authorities, only for people who, as they claim, need papers outside the country. But other than that, nobody cares. Nobody even believes. Nobody even knows that we've got a law for the registration of customary marriages. But the truth of it is, if you can produce a certificate that shows that you are married to the person under customary law as per the certificate, fair enough. But in recent times, I need to be honest and frank and say that the definition of a spouse has now been expanded sufficiently to include anybody who lived together with a person and the two of them held themselves out to the world as husband and wife. And what it means is that even if the person did not really perform customary rites as we know it, the law can still infer a relationship of husband and wife from their outward conduct.
Okay.
And so if you perform customary marriage, fair enough. If you register the customary marriage, fair enough. But we know that even if the customary marriage is not registered, that would not mean there was no wife. So therefore, somebody to qualify as a spouse, there must be evidence that there has been some marriage. And in Ghana, when we talk of marriage, there's always evidence of how people come together to be called husband and wife. But issues always arise when disputes arise, when people claim that this person for this reason is not a wife. When there's no agreement as to who is a wife, there's always a way. Evidence will be led, and the court will have to conclude at the end of the day whether somebody was a spouse in the sense of being a wife or a spouse in the sense of being a husband.
Great.
Yes.
Thank you so very much. Let's now get onto the phone lines and get onto Zoom and take your questions. So, Salifu, you are calling up from Obuasi. This is the law. What's your question, Salifu? Good afternoon. Go ahead with your question.
Yes. I am a police prosecutor.
Okay.
And I am handling a case similar. A man, he has two wives. And then he has two buildings. Let me say 2 houses. And then gave one to the first wife. Hello?
Quickly, go ahead. We are listening.
He has 2 wives and built 2 houses. He gave one to the first wife and then the other one to the second wife. And then the first wife son is claiming a room in the second wife's property.
When you say he gave one, he distributed the 2 among the 2 wives. How did he do it? Was it done by a certain deed, as in an instrument, giving the houses to them?
The houses were given to them by, it's like he called the, hello.
Did he give it to them by in writing? There's something we call a deed of gift or something like that.
He did it in writing.
Okay.
And now one of the first wife's son is claiming one
a
of
portion
the rooms.
in the other person's property, and you don't know what to do.
When there was a conflict between them, and it's raining here, so it's like the network. Oh.
All right, thank you very much, Sarifu. Eric from Edukrom. Hello, Eric. Let's hear you.
Hello, Samson. Good afternoon.
Yeah. Eric, go ahead.
Yeah, I wanted to ask Mr. Painter this scenario. A man dies with 2 houses with children from 3 wives, but he's made away the senior wife passed on, and then he didn't marry the other 2 wives and left 2 houses with cars. How is it going to be distributed?
Thank you very much. And let's hold on there. Let's start with Evans Eric from Edukrom.
You know, in the situation that Eric describes, if a person in his lifetime makes a gift, we call it gift inter vivos, a gift that you make in your own lifetime. And if you have made a gift, either in the presence of witnesses, even without a document, it remains a valid gift as far as there could be proof that that gift was made.
Right.
If he did it with a document, even the better.
Right.
So therefore, at the time of his death, those properties are not his. Those properties have devolved to the persons to whom he made a gift, and it is valid for all purposes. Okay. So no issue can arise for interstate succession law in respect of those 2 properties.
Right.
And the son who is behaving the way he's behaving, if the fact is all that you have given us, then he's very misconceived. Right. And somebody must look him in the face and tell him that he's very wrong in the view that he has taken of what he claims to be a portion.
Remember that lawyer said last week and this week that it is your property that can be distributed, estate. If you have already given it out, it doesn't belong to you anymore. And then Salifu, the police officer, I think is questioning, if you get it, about the man, having 2 wives, 2 houses. He gave it to the 2 of them, and then one is claiming a room in the other one.
I think that was for the first guy whose question I've answered.
Yes, Salifu.
Yes. I mean, that's the first guy who asked that question. That's why I've made a point that
all right.
If he made those valid gifts.
Let's hear Evans from Kumasi. Please go straight to your question, Evans.
We do from a linear system of inheritance. Now, my grandmother has a land. And then my uncle has now possessed it and then used it for a cashew farm. Can he will it to the children, or if he doesn't do any will, after his death, who owns the cashew farm?
Thank you very much. Thank you, Evans. Yes.
Listen, if the land belonged to your grandmother, then the property ought to be distributed in accordance with the law at the time of her death, which is very simply that if she did not have a husband and she did not have any children of her own. If she had children, then the property goes to the children. It's as simple as that. So therefore, that property then becomes the property of the children. And the children, they hold it as we call tenants in common. That is to say, they hold it equally. But if your uncle took it, listen carefully, your uncle was a son of your grandmother, then it was his right to take the property by reason of her mother dying intestate and the property devolving to him. But then, because it's a piece of land, it haven't told me it's a property, but if it's a piece of land, then it fell to be distributed in accordance with the law that provides that it must be distributed in the formula that I've already given, 316, right. 916, and 1/4. That's the way it ought to be distributed.
And the first thing is that he ought to have gone to court to obtain the letters of administration. And Koku Pencil emphasizes that sometimes it's not everything that you really need a lawyer. You could walk into the court premises, the district court, the circuit court, and there are registrars there who may help you. You may not exactly need a lawyer, but it's good if you can get a lawyer to assist. Emmanuel from Teshi. Hello, Emmanuel.
Good afternoon.
Hi, go ahead with your question.
Yeah, my question is, what happens to the children of a person who dies without making a free of the children?
What happens to a person who dies without making a will?
The children of someone who dies without.
All right, you joined us. You joined us late, but you can recap that.
If a person dies without a will and has left children, depending on whether he has wife or not, but if he left children only, the law is that the children are entitled to 3/4 of his estate. If he left a house, it belongs to the children.
Straight away.
Straight away.
And if there are cars that are not used for commercial purposes, they all belong to them straight away. All right, thank you. We have Paul. Paul, you are calling us from Teshi. Straight to your question.
Yes, please. Good afternoon. Please, how about if the property acquired is acquired from a family business where the children and then the mother is involved?
Okay.
The family business.
Thank you very much. Property belongs to the family, he says.
A family property remains a family property. The rule about family property is that one person cannot develop it and acquire an interest in it.
Right.
Whatever you do in respect of family property, if you've got family land, you go and build a house on it and you die, the property goes back to the family. Exactly. You haven't got any share in it by reason merely of the fact that you want to improve it or put a house on it. So let's distinguish that very, very clearly.
Right.
Family property retains the character of family property unless for any reason it is passed on. In other words, the family itself means to agree that they will vest an interest to anybody. That is to say, create an interest for anybody.
So let's go to Zoom. And last week, somebody had a similar question when we dealt with wills. The question of the will is that it is your property only that will be put in there, or the portion of your interest that will be put in there. So you can't go and take a family property and put it in your will. you have done nothing. All right. Emmanuel, let's start with you. Hello, Emmanuel. Oh, Emmanuel, I'm mute. You are talking, but I can't hear you.
Hi, good afternoon, Sam.
Good afternoon. Go ahead.
Right. I need some clarification on something. A man died and an administrator was appointed for his property. But I came to rent the premises when one of the man's children was still living in there. I didn't know in fact, there was an administrator. So after years of using the place for my clinic, I got to realize that that issue was in court. So finally, the ruling was that the administrator should come and take over. Now, the agreement I entered with the woman has been squashed, like thrown away by the administrator. Now, what I want to know is that can I enter into a tenancy agreement with someone who has been appointed by law to distribute the properties of the deceased, like the administrator?
All right, thank you very much. You haven't walked into a lawyer's office all this while. I don't know what you're waiting for. Free legal services. Let's go on.
Listen carefully. The law is that an administrator, you see, an administrator's office is just for 1 year. They are supposed to distribute an estate, and at the end of it, if it relates to real property, that is to say what in Ghana we call landed property, a bird or a house, there is something we call a vesting assent that the administrator ought to execute in favor of the person who is entitled to the property. It is not true that an administrator can of his own will deal with the property which is not his, unless, of course, his office as administrator coincides with that of a beneficiary. Right. But even then, the law is clear that without a vesting assent, without the creation of vesting as any dealings, any transactions in relation to a property that falls under an estate is null and void. Okay. Meaning that the administrator, when he dealt to do in those circumstances, he had no power to do what he did. The property was not his. He was only an administrator, and he owed a duty to the owners of the property to vest it in them. So I'm sorry, whatever deal that he did with you, maybe because he also didn't act by a lawyer, you didn't do what we call due diligence. You just went ahead and you thought you had a perfect agreement. Right. I'm sorry you are caught by the law, and the only remedies that you have would be against the person who deceived you into getting into that situation.
Thank you very much. We're getting a couple more of you. Do I get to Kojo Nchi before Kojo from Sefi? Okay, yes, Zoom. Hello, Techno, let's hear you. And remember, even if it's a will or it's an LA, in the end, the properties must go to the people by way of a vesting assent. Then the properties get into the names of the beneficiaries and they become the owners going forward. Yes, Techno, let's hear you.
Yes, sorry, Bartholomew.
Yes, go ahead, Bartholomew.
Yes, mine is similar to an earlier one. That is, Ghana, we have this traditional way of doing business. So if I invest with my brothers and I have to die, how will that property to be calculated and given my?
All right, did you hear him?
Children?
Partly.
You said if you invest with what?
Yes, with my brothers or sisters.
Okay. So, as in, your brother has a land and you go and build on it. Is that it? Be specific about your circumstance.
No, like any other. Yeah, okay. Of animals.
Your line is very bad.
But if you can hear me, listen quite carefully.
Yeah.
Whether it's your brother, whether it's your sister, whether it's family, if it is not yours or it belongs to all of you, the rule is quite clear. You ought to be guided by some agreement among yourselves as to what interest you acquire by reason of what you put into it.
What your share is.
That is so. If you don't do that and you develop it for all, and you got no better interest than any one of them.
All right. Kojo from Sefi, you'll be our very last caller on phone. Hello, Kojo.
Samson, good afternoon.
Good afternoon. Go ahead.
I want the player to explain further the quota where he said it should be distributed according to customary.
Okay.
Let's say if I die and I have only just one brother, and after distributing my estate to my children, the quota, my brother is also about to set the quota.
All right, thank you. Thank you very much. You use the money experience.
Right.
And remember when you say the estate, it includes money. The
Right.
people leave money in the bank and it is shared.
Right.
So the quarter half.
Yeah, you know, what I'm saying is, you see, when we talk of quarter 316 with reference to properties and whatever, it's very difficult. And that's why, by way of analytical listen, I showed you that for the sake of the discussion, I just gave a value. Yes. Assuming that all the properties were sold, assuming that all the properties were valued and put together. Other than that, you can't take a hacksaw and divide a house into the portions that I'm talking about. It is only for purpose of this discussion, but the only point that I'd like you to understand, the law assumes that if you put a value on everything that we call the residue of the estate, just take it in mind that the surviving spouse take 3/16, the surviving children take 9/16, and the quarter, 1/4 of it goes to surviving parents, and 1/4 of it goes to be distributed in accordance with custom. If it is money, we all know how it is done. But if it is properties and stuff, listen very carefully. Everything that I've said here this afternoon about the law is subject with due respect to the use of common sense, practical common sense in doing some of these things. And one of the things that I keep telling my clients and everybody is that in the absence of a firm agreement by the parties as to how distribution ought to be done, the court will always find a formula.
Great.
And if the court is or the party unable to agree,
right,
the last resort
Great.
will be for the particular property to be put on the market.
Right. And remember that the distribution he has given you is after the surviving spouse and children have gotten their portion of one. If it's a house, they take the house. If shuttle, including vehicles, they take all of it before we start all of these. We have run out of time, but what an interesting discussion it has been, empowering discussion it has been on the law, because here it is your health law and it is your legal light. My guest has been Kweku Pencil, head of Pencil & Co. I'm Samson Ladi Anyanini. Join us again next week, God willing. We'll bring you another edition of the show to empower you. Thank you so much for coming.
You're welcome.
Right.
Thank you very much.